It seems we too frequently forget that the courts are part of our government. Now, several groups petitioned the government in the form of the federal courts for a redress of their grievance that state actors other than their legislatures change the manner of holding elections. Now, when the Supreme Court denied to hear these cases, it reminded me why we should not blindly trust the courts to protect our rights. Why? Because in many cases, they are the fox guarding the henhouse. And we'll discuss that more right here on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Well, hello there, everyday Americans. Paul Engel here with the Constitution Study. That's right, this is where we read and study the Constitution. We teach a rising generation to be free. We learn to protect our rights, to defend our rights, to assert our rights, and I am glad you could join me. Hopefully you're finding these useful. Hopefully you're finding them educational. Hopefully you are sharing this information. That's what this is here for. It's for you to not only to learn, to open debates, but to share it with others, with friends, with family, on social media, wherever you can. Share this information because that's how liberty remains alive. We keep the sacred fires of liberty burning by having open, honest discussions about what's going on, especially when it involves our federal government and the Constitution. So take that information, head to the website, constitutionstudy.com, share this video, share the article, share all this information. That is the biggest thing you can do to help keep the Constitution Study going. If you want to help me financially, if you want to keep this up and running, click the donate button. All those donations go directly to keeping the website going, to keeping these videos coming out, the podcast, the articles. That all happens there. So anything you can do there to help would be greatly appreciated. Also, if you want to head over to Scholars, constitutionscholars.com, you can join up, you can sign up for free, and you can find other patriots, other people interested in the Constitution in your state, and you can start discussing what's going on in your state as well. But with that, let's talk about these election cases. The 2020 elections exposed a number of issues in the election process for several of the states. By far the most egregious actors were members of the courts. From the usurpation of the legislative process by state courts to the denial of the right of petition by the federal courts, especially the Supreme Court, I believe there is ample evidence of the failures on the part of the judicial branches of the governments at many levels. And with the American people placing so much trust in the courts to protect their rights from overreach of government, this does appear to be a case of the fox guarding the henhouse. Today, I want to focus on a recent case out of Pennsylvania, not because what happened there was worse than what happened in other states, but because several cases which were brought before the Supreme Court of the United States were summarily dismissed. This continued exposing the American people to fraudulent elections and bringing further into question whether the powers governments are exercising are at the consent of the governed. Now, the cases of Republican Party of Pennsylvania versus DeGraff and Reed and Corman versus Pennsylvania Democratic Party are the latest election cases out of the Commonwealth of Pennsylvania to reach the Supreme Court of the United States. Their petitions for writ of certiorari, or the judicial review of the decisions, were denied by the Supreme Court. Now, in his dissent to these joint denials, Justice Thomas brings up some very interesting points, issues that should not only bring into question the legitimacy of our elections, but the dependence we have put on the courts to get what we want. Quote, "The Constitution gives to each state legislature authority to determine the manner of federal elections." This is Article 1, Section 4, Clause 1, and Article 2, Section 1, Clause 2. Now, this may seem like a simple point, but the Constitution of the United States is quite clear. The manner of holding elections for United States Senator, Representative, and President, or at least presidential electors, is to be determined by the legislature of the several states. Article 1, Section 4, Clause 1 reads, "The times, places, and manner of holding elections for senator and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the place of choosing senators." And Article 2, Section 1, Clause 2 reads, "Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress." Yes, Congress can pass laws altering the regulations for elections, not the courts. Yet that is exactly what happened, and not just in Pennsylvania. Now, from Justice Thomas's dissent, quote, "Yet both before and after the 2020 elections, non-legislative officials in various states took it upon themselves to set rules instead. As a result, we received an unusually high number of petitions and emergency applications contesting those changes. The petitions here present a clear example." See, what we have here is a clear violation of the Constitution of the United States. As shown, the U.S. Constitution delegates the authority for determining the manner of electing federal officials solely within the state's legislature, unless it's altered by Congress. But in 2020, we had several other actors illegally changing the rules of conducting the elections. Specifically, the Pennsylvania Supreme Court attempted to change the deadline and requirements for accepting mail-in ballots. Quote, "The Pennsylvania legislature established an unambiguous deadline for receiving mail-in ballots, 8 p.m. on Election Day. Dissatisfied, the Pennsylvania Supreme Court extended that deadline by 3 days. The court also ordered officials to count ballots received by the new deadline, even if there was no evidence, such as a postmark, that the ballots were mailed by Election Day." Now, why did the Supreme Court overrule the legislature and extend the deadline? Well, again, from Justice Thomas's dissent, quote, "Then, in response to COVID-19, the legislature again amended the law, but decided not to extend the receipt deadline further. Displeased with that decision, the Pennsylvania Democratic Party sued in state court. It argued that the court could extend the deadline through a vague clause in the state constitution providing, in relevant part, that elections shall be free and equal, Article 1, Section 5. Okay, so one of the political parties was displeased with the will of the people as expressed in the votes of their representatives, and they decided to sue. Now, while it has become common practice to attempt to get through the courts what you cannot get through the legislature, look at the rationale by which the Pennsylvania Democratic Party believes the court can give them what they want. From Article 1, Section 5 of the Pennsylvania Constitution, quote, "Elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage." Now, most people agree that elections should be free and fair. But is it interference with a free and fair election to set a deadline for accepting mail-in ballots? Well, if that were the case, wouldn't the Pennsylvania Democratic Party be asking the courts to do exactly the same thing, just with a different date? Or is it only interference if the deadline is set for Election Day? Now, from Article 7, Section 4 of the Pennsylvania Constitution, quote, "All elections by citizens shall be by ballot or by such other method as may be prescribed by law, providing that secrecy in voting is preserved." Well, that seems pretty simple. The method of casting mail-in ballots was established by law and did not infringe on the right of the people of Pennsylvania to a free and equal election. So what did the Pennsylvania Supreme Court do? Well, from Justice Thomas's dissent, quote, "On September 17th, it held that this free and equal provision enabled the court to extend the deadline 3 days to accommodate concerns about postal delays." You see, the court decided that it knew better than the representatives of the people of the Commonwealth, and that an arbitrary extension to the deadline be put in place. However, that's not all. Quote, "The court also ordered officials to count ballots received by the new deadline, even if there was no evidence, such as a postmark, that the ballots were mailed by the election." So, as long as you could get your ballot delivered quickly, the court not only extended the deadline for receiving ballots, but for casting them as well. In other words, the court rewrote the election law, again violating the constitutions of Pennsylvania and that of the United States. Now, Article 2, Section 1 of the Pennsylvania Constitution reads, quote, "The legislative power of this Commonwealth shall be vested in a General Assembly, which shall consist of a Senate and a House of Representatives." And Article 2, Section 1, Clause 4 of the U.S. Constitution reads, quote, "The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States." So we have the Pennsylvania Supreme Court ignoring the constitutions of both Pennsylvania and the United States. This should be a clear-cut case where the right of the people to petition their government for a redress of this grievance is warranted. And that is exactly what several people did. Quote, petitioners promptly moved for emergency relief, filing application for a stay on September 28th. That application easily met our criteria for granting relief. Not only did parties on both sides agree that the issue warranted certiorari, but there also was no question that the petitioners faced irreparable harm. Petitioners further established a fair prospect of certiorari and reversal. So we have a petition for emergency relief filed in federal court, a petition that, according to Justice Thomas, easily met the Supreme Court's criteria for granting relief. Both sides agreed that the issue warranted being heard by the Supreme Court, that petitioners faced irreparable harm, and that there was a fair prospect of reversal. So what did the court do? Quote, despite petitioners' strong showing that they were entitled to relief, we divided 4-4 and thus failed to act. The court split 4-4 on the question of granting certiorari, meaning it was not granted and the case was not heard. But this didn't end there. Quote, 4 days later, petitioners filed the first of these petitions and moved to expedite consideration so the court could decide the merits before Election Day. But by that time, Election Day was just over a week away, so he denied the motion to expedite, even though the question was of national importance, and there was a strong likelihood that the state Supreme Court decision violates the federal Constitution. Again, some in the Commonwealth of Pennsylvania petitioned their government in the form of the federal judiciary for a redress of their grievance. Rather than dealing with the issue, which was urgent, important, and likely to lead to an overturning of the Pennsylvania Supreme Court opinion, the U.S. Supreme Court denied to hear the case again. Now, the denial of certiorari on February 22nd is now the third time the people of the Commonwealth of Pennsylvania have had their petition denied by the Supreme Court. Now, while the opinion does not specify why the petition was denied, we do seem to get some clues about the possible reasons from Justice Thomas's dissent. Quote, we are fortunate that the Pennsylvania Supreme Court's decision to change the receipt deadline for mail-in ballots does not appear to have changed the outcome in any federal election. This court ordered the county board to segregate ballots received later than the deadline set by the legislature, and none of the parties contend that those ballots made an outcome determinative difference in any relevant federal election. At first blush, it may seem reasonable to address this question when it next arises. After all, the 2020 election is now over, and the Pennsylvania Supreme Court's decision was not outcome determinative for any federal election. But whatever force that argument has in other contexts, it fails in the context of elections. For at least 3 reasons, the judiciary is ill-equipped to address problems, including those caused by improper rule changes through post-election litigation. See, the Supreme Court ordered that the ballots received after the legal deadline be segregated to prevent contamination of the vote should the court decide to overturn the opinion of the Pennsylvania Supreme Court. Now, it appears that the extended deadline did not change the outcome, at least of the presidential election. A very likely reason why the court decided not to hear the case is that the illegal actions of the Pennsylvania Supreme Court did not change the outcome of the presidential election. In other words, the court appears to prefer kicking this particular can down the road rather than deal with the blatantly illegal actions of the Commonwealth. Now, while Justice Thomas goes on to give reasons why the court should not wait until the next time to deal with this problem, he misses what to me is the most important reason of all. That is, the justice's oath to support the Constitution of the United States. Quote, the senators and representatives and members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. That's Article 6, Clause 3. The fact that it appears the illegal interference in the election process by the Pennsylvania Supreme Court did not impact the outcome of the election. What about the right of the people of the Commonwealth to determine the manner of elections via their representatives? What about their right to equal protection under the law? And yes, what about the next time this happens? And not just in Pennsylvania, but other states where courts illegally meddled in the election process. Part of the reason our Constitution was created was to establish justice. If such blatantly illegal actions are allowed to continue unabated, where is justice? Some may say that since the outcome of the election was not changed, no harm, no foul. But there was harm. There was harm to those who questioned the legitimacy of all of the Pennsylvania elections. Did the ballots cast after the legal deadline impact races other than those for the federal office? Are there people who legally won elections but were denied because of illegally cast ballots? And what about the damage to the rights of the people of the Commonwealth to consent as to how their government runs? What the Pennsylvania Supreme Court did was beyond the consent of the people of Pennsylvania. Yet so far, they have not been called to account for this malfeasance. And since this election impacted all of the states, not just Pennsylvania, what about the harm to the citizens of other states who cannot trust that those in federal office were chosen by free and fair elections? In short, the justices of the Supreme Court don't seem to place a premium on their oath of office or on the consent of the people of the United States who employ them. This is what happens when the American people place their trust in courts to protect their rights. While most Americans appear to view courts as impartial arbiters of fact, they are, in fact, government agents with all the baggage that comes with it. Why do you think people refer to justices as either conservative or liberal, Democrat or Republican? Because if you want to have a seat as a judge, you must play the political game. And if you think that game stops when you attain a seat on the high court, you're fooling yourself. Courts are made up of people who have their own opinions and agendas. And in this day and age, it appears that once someone assumes a position on a high court, their opinions are above challenge. But that is not legally the case. If, as the Constitution says, we the people established this Constitution and its government through our states, then we can fix it. As the Declaration of Independence says, quote, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. I do not think the government has become so destructive of our rights that we need to abolish it, at least through force of arms. I do, however, believe it is far beyond time we the people alter it by hiring people to represent us and our states who will abide by their oath to support the Constitution. And not just at the federal level, but more importantly, at your state, city, and county level as well. As President Garfield said, quote, now more than ever before, the people are responsible for the character of their Congress. If that body be ignorant, reckless, and corrupt, it is because the people tolerate ignorance, recklessness, and corruption. If it be intelligent, brave, and pure, it is because the people demand these high qualities to represent them in the national legislature. We have those who sit on the courts because the people have elected representatives who place them there. And they remain on the courts because the people continue to elect representatives who let them stay. If the courts are ignorant, reckless, and corrupt, it is because we hire ignorant, reckless, and corrupt people to exercise our sovereign power in the legislature. So the people of Pennsylvania, I ask, why are you looking to Washington, D.C. to fix your mess? After your governor appointed the justices on the Pennsylvania Supreme Court, you voted to keep them around. Is anyone putting pressure on the Judicial Conduct Board to discipline these judges who voted to steal your right to control the voting process? Who is pushing to have them voted out of office? Why does it appear that you are begging for the federal government to come to the rescue rather than cleaning up your own mess? Speaking of the federal government, the federal courts exercise the judicial power of the United States because we the people said so. If those who currently sit on the court will not exercise that power to establish justice, domestic tranquility, and the general welfare of the United States, then they should be removed from office for their bad behavior that they have exhibited. If we cannot trust the justices of the court to be impartial arbiters of facts and law of a case, if we cannot trust them to abide by their oaths, to protect our rights, and to assure due process, then we should treat their opinions with the same deference they give to their oath of office. If they won't abide by the compact that created their office, then why should we abide by their opinions? I find it interesting how often people look for a redress of their grievance from a court as if the court is not part of the government. Now, going to the federal court for a state issue, there's a lot more there that I haven't unpacked. But what we have here is, again, proof that the court is a political body, not a judicial one. Or certainly not a just one. Because they've taken the laws and the Constitution and said, we're not going to deal with it, even though we're pretty sure what they did was wrong. We're not going to deal with it, or we're going to find an excuse to not deal with it. We're just going to kick the can down the road, which means it'll happen again. So the next time a state court violates the Constitution of their state and of the United States and usurps the power of the legislature, well, we can hopefully remember that the Supreme Court is part of the problem. Because when they had a simple, easy, clear-cut opportunity to offer their opinion, they chose not to. They're cowards. Worried more about, I don't know, how they're going to be viewed than justice. Which is really interesting when I compare this to another case I'm going to be talking about in a few weeks about free speech and what the court did. But for now, let's recognize you can't depend on the courts to protect you. You can't depend on the Supreme Court of the United States. You can't depend on the Supreme Court of your state. We have to do it ourselves. That means getting engaged. That means only hiring people to represent you who will abide by their oath of office. And if they won't do that, they need to be removed, period, full stop, end of story. We, the people, hire these representatives. We should be engaged with them. We should be more worried about the rule of law than getting our way. And as long as we're willing to use courts to do what the legislative process doesn't allow, what the constitutional process does not allow, we have no reason to complain that we're no longer a country of laws, because we're using the courts to circumvent the laws anyway. So hopefully you found this a little educational. Head over to the website, constitutionstudy.com, find out more about what we're doing. Share this video, share the articles, maybe support the work that we're doing. If you want to get deeper, if you want to learn more about becoming a Constitution scholar, go to constitutionscholars.com. Find out more. You can register for free. You can find other patriots, other people who are interested in this, in the discussion, interested in the Constitution, both the United States and of the several states. And if you want, you can even sign up for an apprentice level membership, and you can start your process of really becoming a constitutional scholar. That's all over there at constitutionscholars.com. Please keep your eye out for other events and things I'll be doing. I've got a lot of irons in the fire, and I hope to get some more done here in 2021. If you would like me to come speak at one of your events, or you have someplace you think I'd like to attend, contact me through the website, constitutionstudy.com. Just contact Paul, send me a note. With that, I hope you enjoyed this. I hope you find it useful, and I hope I'll see you here next time on the Constitution Study.
There's one thing you have to know.